Mr. Honda.
Thank you, Mr. Chairman, and welcome. And before I start, I just want to thank you for your service to this country. And certainly, as a third-generation Japanese American who went through internment, and this country set aside our Constitution, I place my confidence in your ability to fulfill the laws of this country, and so for that I am very appreciative for your service. As you know, that the decennial census is one of our nation's one of our most important civic responsibilities. It's underway now, and historically, some population groups are more reluctant to respond because they're fearful that the government agencies other than the U.S. Census Bureau will have access to their personal responses and might use that information to take legal action against them. The 2010 census is the first post-September 11th enumeration. I and several of my colleagues recently asked the Justice Department to analyze the strict census confidentiality provision in light of the newer Patriot Act provisions that allow the federal government to seek information and to gather data about individuals suspected of terrorist activity. And we appreciate your recent response to our letter. And would you confirm my understanding of your analysis? This is what I understand. That no data sharing or data seeking provisions of the Patriot Act supersede provisions of the Census Act that prohibit the Census Bureau from sharing any personally identifiable information with any other government agency or court of law. Is that a correct analysis and determination?
I was going to say yes, but I wanted to make sure, so I checked with all of my my colleagues back here, and that in fact is correct, yes.
I do that with my staff too, thank you. Because I think that when we tell our communities, especially the recent arrivals and those who are citizens in waiting, those who are new citizens, we just want them to feel confident that when the knock on the door is there, and we do the outreach and spend all this money and effort to fulfill the constitutional mandate of counting everybody who's here, we want them to feel confident, as I do, that their information will be used only in a way to provide information so that we can come up with all kinds of programs that would benefit the people of this country. So I appreciate that input. The increased resources the administration has continued to request for Indian country law enforcement programs and initiatives through the Department of Justice in this 2011 budget request. The administration is proposing new bill language for 7% tribal set-aside of funding within state and local law enforcement assistance and other DOJ accounts. This 7% tribal set-aside language would replace traditional bill language that has been carried out in recent years that specify particular funding amounts for the various Indian country law enforcement programs, such as tribal courts, detention facilities, and Indian youth. So what assurances does this subcommittee have that these key core component programs serving Indian country will continue to receive an adequate base level of funding in 2011?
Well, I think that one of the things we want to do is to work with the people in the tribal lands to make sure that the money is spent in appropriate ways, to use our Inspector General, the other mechanisms that we have to ensure that money is being spent programmatically in the way that is intended by Congress and is consistent with what the administration's goals are. I attended a listening conference in Minnesota, I guess late last year, to try to, as we were developing the budget, to try to listen to the people who live on those lands. What is it were their needs? And I think we have tried to identify in the budget, come up with a certain amount of flexibility, but also a certain amount of rigidity at the same time, so that the needs that they identified and that we see are met. And so I think that we have struck a right balance here.
Has there been any discussion during that time, or the the perception that Indian country laws, based upon culture and history, tradition, may be different if it were administered. Well, are there Indian country courts, Indian courts that are able to have the same kind of support from us and be able to administer the laws that they have traditionally on their own lands? And is there a difference in friction in that area? And is there any work being done to sort of address those differences?
Well, I think we are trying to be sensitive to the cultural differences that exist, at the same time trying to, in terms of all the law enforcement instruments that we see there, trying to support them in such a way that they are effective by 21st century standards. Again, being sensitive to those cultural differences, but ultimately just making them effective. If one looks at the crime rates that you see in Indian country, if you see what a young girl born in Indian country and who lives her life there can expect in terms of sexual abuse and sexual violence, it is really, it's breathtaking. And so what we have tried to do is come up with ways in which we are supportive of enforcement efforts, supportive of prevention efforts, at the same time being sensitive to the cultural differences that I think you are right to point out.
Given that distinction and that kind of a case, in terms of the civil rights that we have, in terms of the kinds of access to health and things like that, or education, would the reverse be applicable to Indian country if there's a lack of that and there's an expectation that somehow we're partners through this treaty that we have and in the context of their sovereignty, that do civil rights laws apply in that case in an Indian country from the perspective of our own laws? I'm not sure if that makes sense, but it's
no, I think I understand what you're saying, and I'd have to check on that and see exactly what the applicability is of our laws. I think they only reach so far. I think that the monies, but I'd want to make sure that this is accurate. The monies that we give are to support the laws that they have and that they have to enforce, and that not all of our laws, as I understand it, are necessarily applicable on tribal lands. But that is something I should check into and get back to you with a more definitive answer.
Okay, I appreciate that. In the area of the Executive Office for Immigration Review, in citing the complexities of immigration cases, such as unmanageable dockets, unrealistic case completion deadlines, on average, immigration judges have probably less time than before to dispose of a case, despite their burgeoning caseloads. What steps have your office taken to ensure that these judges and the Board of Immigration Appeal members can manage their caseloads and then to both reduce the heavy load on the circuit courts and ensure that immigration cases receive adequate attention in administrative courts? What concrete actions have been taken to ensure that the immigration judges have the tools and resources to meaningfully adjudicate these cases?
One of the things that we are doing is to try to hire just more judges, to have more people to hear these cases. We are looking at adding, using against $11 million that would include 125 positions, 31 attorneys, to add 21 immigration judge teams, and 10 Board of Immigration Appeals attorneys. So we want to have more people doing this work, and at the same time we want to increase the training that we give to these people. I think we've made some substantial progress when it comes to what our immigration judges are doing. I had a meeting just yesterday, maybe the day before yesterday, with a group of Article 3 judges who review these cases, and they said that they thought over the last couple of years that they had seen a noticeable positive change in the work product that's coming out of immigration, the immigration judges, the trial judges.
Okay, how much time do I have?